In this present lecture, we'll discuss another important landmark judgment relating to right to die with dignity, whether it is falling under right to live with dignity, and that is Kaur vs. State of Punjab, and which was decided in the year 1996. But this very fact of this case is somehow different from those cases that we have already discussed, as it relating to adding to suicide, or in particularly relating to abatement to commit suicide, which is provided under section 306 of Indian Penal Code, and which was held valid in the landmark judgment of 1994 in Piradhinam and Nagbhushan Patnaik versus Union of India. So, the very introduction that we would like to discuss the very case revolves round Section 309 of Indian Penal Code and also Article 21 of the Constitution of India. So, the judgment delivered in this particular landmark judgment held and cited some previous landmark judgments that, like Maneka Gandhi versus Union of India, and that was the case of 1978, where it was held that right to life and personal liberties are guaranteed as fundamental rights, and it could not be deprived unless until procedure established by law. It also established the principle of natural justice. So also after that in Hussein Khatun versus State of Bihar, where the article was expanded in containing that right to speedy trial is a part of right to life as provided under Article 21 of the Constitution. So also, in another important landmark judgment in that case, that is the case of Francis Corelli Mullen versus the administrator of Delhi, where Justice P.N. Bhagavati said that Article 21 is a constitutional value that is very important in a democracy. So also, in another important landmark judgment, that is Olga Tellis versus Bombay Municipal Corporation in 1985, the judgment of Supreme Court expanded the very scope and ambit of Article 21 of the Constitution by including right to livelihood as an integral part of right to life and personal liberty as provided under Article 21 of the Constitution. So now we'll discuss exactly the very scope of this article is supposed to cover all those cases where a person is deprived of his life or liberty without any reasonable justification, as it is provided that it could be deprived only by procedure established by law. So, in this context, we'll discuss the facts relating to this judgment. So, the judgment was filed against the High Court judgment under special leave petition, and in particularly relating to abatement of suicide. So, Section 309 of Indian Penal Code punishes a person who attempts to commit suicide and does any act in furtherance of the same. Essentially, a person who dies by suicide cannot be punished, but a person who fails in the attempt to commit suicide will be punished by law, as provided under Section 309 of Indian Penal Code. This action, however, has been challenged several times. First time in Maruti Sripati Dwal case of 1986 where the Bombay High Court delivered the judgment in favor of the petitioner by decriminalizing Section 309 Soul Suit. Delhi High Court in State Sanjay Kumar Bhatia in 1994 also declared the very provision as unconstitutional and harsh. So, the very grounds raised as whether it is falling under Article 21 of the Constitution and if it is falling under the provisions of Article 21, so right to die with dignity, whether it is falling under right to live with dignity. So, the very judgment in this particular case was held that life and death, so right to life and right to die, both contradicts the very challenge. So the challenge in this particular fact that was raised in the sense that the very petitioner Gan Kaur and her husband Harban Singh were accused of aiding the suicide of their daughter-in-law Kulwant Kaur since they wanted their son to marry someone else, someone who could bring them dowry. The trial court had convicted them under Section 306 of the Indian Penal Code, which deals with those offences of abatement to commit suicide. So both of them were sentenced to rigorous imprisonment for 7 years and were also liable to pay a fine of Rs 2,000 each. In the event that they did not pay the fine, they were sentenced to 9 months in prison. The convicts appealed to the High Court, but it upheld the decision of the trial court. The only change made by the Honorable High Court was to reduce Kaur's sentence from 7 years to 3 years of rigorous imprisonment. The sentence for her husband remained unchanged. So finally, the appellants approached the Supreme Court through a special petition. They challenged the constitutional validity of Section 306 of Indian Penal Code as being violative of Article 21 of the Constitution, as they argued that as it was held in P. Rathinam vs. Union of India, Article 21 includes the right to life as well as the right to end one's own life. But the landmark judgment delivered in P. Rathinam and Nagbhushan Patnaik vs. Union of India in 1994, the apex court held that the section 306 of the Indian Penal Code dealing with prosecution for abatement of committing suicide is valid. So, here, a person convicted of aiding and abetting suicide was simply assisting a person's right to commit suicide. So, the legal issues raised here as relating to Article 21 and Section 306 and 309 show the very legal issue whether or not Article 21, which addresses right to life, whether it constitutes also right to die. Further, it raised the question regarding Section 309 of the Indian Penal Code is violation of the fundamental rights provided under Article 14, which deals with right to equality and equal protection of law, and Article 21 of the Indian Constitution, which provides right to life and personal liberty. Further, the next important legal issue is relating to the constitutional validity of the provisions of Section 306 of Indian Penal Code, which punishes any person aiding suicide or abatement of committing suicide. So the very arguments of the appellant regarding unconstitutionality of Section 306 and the very judgment of 1994 delivered in P. Rathinam and Nagbhushan Patnaik versus Union of India, then the argument that right to die includes under right to live a right to life as provided under Article 21 of the Constitution, and that is in particularly right to live with dignity. And further they argued against the very section 306 and 309 of Indian Penal Code as discriminatory and arbitrary. So the very arguments led by the counsel of the petitioners that the judgment passed by the trial court is an erroneous nature. It was strongly alleged that there was no abatement of any kind. The appellant had approached the High Court to plead that she wanted to get rid of the said allegations. The contention was that Section 306 of the Indian Penal Code should be held constitutionally invalid by referring to the case of P. Rathinam vs. Union of India, in which the court declared Section 309 of the Indian Penal Code unconstitutional by stating that it is a violation of Article 21 of the Constitution. Further, the appellant's argument is that in P. Rathinam case it was held that right to die falls within the ambit of Article 21 of the Indian Constitution, and that any person aiding the enforcement of the right to die is merely aiding the implementation of Article 21, which is a fundamental right and cannot be penalized. The arguments of the appellant further held that on behalf of the petitioner further that the term life does not mean mere animal existence but the right to live with human dignity and enhancing the quality of life. As a result, a person who has the right to die or end his own life. Further, the appellant argued that one of the attorneys of the appellant contended that Section 309 of Indian Penal Code is violative of Article 14 of the Constitution and should be held unconstitutional on the grounds that the provision is discriminatory and arbitrary in nature. So, in response to the arguments of the appellants, the respondent, that is the state of Punjab, where it was laid down the arguments that the decision of the trial court and the high courts were referred, and Section 306 of Indian Penal Code and Section 309 of Indian Penal Code, and also the provisions of Article 21 of the Constitution. So the respondent in this case, that is, the state wanted the decision of the trial court and the high court to be upheld by the Supreme Court. Further, the respondent strongly argued that Section 306 of the Indian Penal Code talks about abatement of an attempt to commit suicide, which is an independent provision on its own, and hence it should not rely for validation on section 309 of the Indian Penal Code. Further, section 306 is constitutional and it does not violate Article 21 and of the Constitution. It was also contended that the very judgment delivered in P. Rathinam and Nagbhushan Patnaik vs. Union of India in 1994 should be struck down since section 309 of the Indian Penal Code is also constitutionally valid. Further, the state responded that right to life is inherently inconsistent with the right to die, and the right to die cannot be said to fall within the ambit of Article 21 of the Constitution. So now we'll discuss the very landmark judgment and the observations made by the Apex Court that regarding right to be killed and right to die and right to life, and further observations relating to attempted suicide and abatement of suicide as one is falling under section 309 of Indian Penal Code and the second one is falling under section 306 of the Indian Penal Code. Then right to die with dignity and right to die. And in particularly aided and assisted suicide or abatement to commit suicide. Further, Article 21 and the constitutional validity of those sections of Indian Penal Code, in particularly section 306 and section 309. So the Supreme Court observed that the right to life under Article 21 of the Indian Constitution does not include the right to die or right to be killed. The Supreme Court propounded that right to life also includes the right to dignified life till the time one reaches the point of death, even including the dignified procedure of death. Hence, it includes the right of a man who is dying to all should die with dignity when his or life is waning. The Supreme Court further observed that the attempt to commit suicide and any person who abets the commission of an attempt to commit suicide do not by any means violate the fundamental rights of Article 14 or Article 21 of the Constitution of India, hence making section 306 and 309 of the Indian Penal Code are constitutionally valid. Further, Supreme Court was of the opinion that life is defined as right to live with dignity, and that the dead shall also undergo a dignified procedure. Therefore, a person leading a life with dignity shall not under any circumstances end his life in an undignified manner. The Supreme Court proposed that no individual end their life has a right to die, and thus it follows that right to die is not constitutionally valid. Further, Supreme Court made certain that right to die with dignity was not confused with the right to die in an unusual manner. The court observed that expediting the process of any person's natural course of death, which by God's creation are impending in nature, and permitting termination of any individual's life under such circumstances is not permitted and available for interpretation as under the provisions of Article 21 of. Therefore, the petitioner's contentions on making Section 309 of the Indian Penal Code unconstitutional, and thus they violate the provisions of Article 21. Further, the apex court also rejected the contention that questioned the constitutional validity of Section 309 on the grounds of Article 14 of the Constitution. Further, the Supreme Court also confirmed that aided suicide attempt and assisted suicide are punishable and considered as an offense for compelling reasons in the interest of society. The main objective of such a provision is to prevent the inherent danger to society in the absence of Section 306 of the Indian Penal Code, which enacts a distinct crime that can survive independent of Section 309 of Indian Penal Code. So the Honorable Court made it crystal clear that arguments made to support the plea for not punishing the person who is committing suicide or any person attempting to commit suicide as falling under Section 309 of the Indian Penal Code, and any person assisting or aiding or any person involved in abetment to commit suicide as it is falling under Section 306 of the Indian Penal Code are constitutionally valid as they don't violate any of the fundamental rights as enshrined under Part 3 of the Constitution of India, and in particularly Article 14, which provides right to equality and equality before law, and Article 21, which provides right to life and personal liberty. So finally, the Supreme Court's five-judge constitutional bench in this important landmark judgment held that right to life is inherently inconvenient with the right to die, as is death with life. So Supreme Court held finally that as it was in P. Rathinam vs. Union of India, which was struck down by the court. Here in this particular landmark judgment making Section 306 and Section 309 of Indian Penal Code as constitutionally valid, and it is not arbitrary, unreasonable, and neither it violates the fundamental rights as enshrined under Part 3 of the Constitution of India. So they are constitutionally valid and making the accused person punishable for the offense committed either under the provisions of Section 306 of Indian Penal Code, which punishes for aiding and assisting or abetment of committing suicide, and also Section 309 of the Indian Penal Code, which punishes for attempt to commit suicide.